I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines, where my guest is my partner, Sean Fagan. We're going to talk about something we talked about last year, some bad laws. These are laws that affect tort, meaning the injury law realm of Louisiana. And the bottom line is, our predictions that it was going to harm the victims and do nothing but make for insurance companies more money has become true. Rights were taken away from you to give insurance companies more money. Bad laws. We need to get involved, folks. So join us on the next Legal Lines with Sean Fagan. I'm lawyer Locke Meredith. If you're battling an insurance company because of a wreck not your fault and they're not calling you back or being fair, whether you hire us at all, give us a call, 272-5555, or email Locke Meredith, Sean Fagan and Associates. You have nothing to lose.
Hi, I'm Sean Fagan of Locke Meredith, Sean Fagan and Associates. When insurance companies have been unfair, we've never been afraid to go to trial. Fighting hard to protect your rights, we never settle a case out of convenience. We only settle when it's right for you. Whether you hire us at all, give us a call.
Hi, I'm Mitchell Meredith. Injuries happen when you least expect them to, making your life more complicated. At Locke Meredith, Sean Fagan and Associates, we know this and we strive to help each of our clients during these times. Whether you hire us at all, give us a call at 272-5555.
I'm lawyer Collins Locke Meredith. Trust is important when hiring an injury law firm. At Locke Meredith, Sean Fagan Associates, thousands have trusted us and gotten the results they deserved. Visit us at LockeMeredith.com. Whether you hire us at all, give us a call, 272-5555.
Hello, welcome to Legal Lines. I'm very pleased to have on the show my partner, Sean Fagan. Sean, great to do this again because we're going to talk to you today, folks, about, again, the legislative process and honestly, how all of us at the grassroots level must participate in this experiment called democracy. Because if we do not participate and tell our representatives, our legislators and our governors and whatever it is title that they held, then it may not work the way it should. And honestly, I think in a lot of ways, our generation has dropped this ball. So I highly encourage y'all to listen to this show so we can become very involved and very powerful as it relates to the laws that have control over us. Let's talk about just the process of making a law quickly, and then we'll talk about that process in the context of a show we did last year where a bill was being proposed to reduce insurance premiums by reducing the rights of the victims of an accident of sorts, of any sort really, and how that worked out.
Well, kind of the general background is the law starts out as a bill, either in the House or the Senate, goes to both sides, they debate it, they fine tune it, and it's heavily influenced by lobbyists as opposed to you.
I think that's a key part. Yeah, who influences the language of the concept, who brings it up, gives the idea to the legislator, and then what happens? So let's talk about the politics of this, and not just the process, but the real world, how it works.
Yeah, even before we get there, the big thing is these laws are usually drafted by the lobbyist.
Exactly.
So it's not even drafted by the lawmaker. It's drafted by the lobbyist, who
wants the law changed or improved for
whoever he or she is representing. So if we look at the law you're talking about, which we talked about last year,
the omnibus. It started out as what, the Omnibus Premium Reduction Act.
Yes,
and it actually was passed as
the Civil Justice Reform Act.
Didn't even mention premium reduction, did it?
Now, what it was sold as to all of us as citizens was that it would reduce our premiums, and that's why all these changes needed to be made, because we would all benefit by lowered premiums. And of course, by the time it was put on the governor's desk, all references to premiums were gone, and it was now just a Civil Justice Reform
And
Act.
they didn't even promise when it was being proposed under the premium title that the insurers didn't agree to reduce their premiums. And guess what, folks? They didn't. They didn't reduce them. They increased them. So let's talk about it. So the lobbyists come in, or any human being can come in and say, hey, my legislator, my representative, I have an idea. I think you need to make this the law or make this change to the law. And in reality, folks may do that, but if you're just one person versus a lobbyist who's carrying, a big wallet to fund campaigns, they might carry a little more weight than your wishes. And if you've got a group of folks who will participate with you in that same desire for that law or modification of law, that's going to carry a lot more weight. But you got to get active. Let's talk about how folks can be involved in that process. You've gone up and testified. I've done the same thing in different forums to influence our legislators based on the reason of our positions, providing them examples and facts.
That's right.
And so the legislature, somebody brings them a law, oftentimes, or a proposed law, a change to a law or a new law. And like you said, it's written by lawyers, because I'd be willing to bet 99% of lobbyists are lawyers or former legislators. And then they go in front of a committee, and typically that's where there's an opportunity for the public to participate, right?
That's right.
Explain how that takes place.
Well, if you're following those things, which 99% of the people on Earth don't have that kind of free time to follow what's going on through the legislature, you can show up and you can request to testify. In other occasions, I've been asked to come testify about laws, and I've gone up and testified. But for the most part, you don't know what's coming down unless you're following the calendar. So that's kind of, it's a limited number of people who actually go in and address it in any great detail, especially the people who are being affected by it. So, they don't hear from those folks. You're mainly hearing from the people that have an interest in it directly because of a business interest. That's usually what it comes down to.
Either they're pro for it, or if those who are against it find out and they go to it. And let's face it, all these bills are written by lawyers in the end, and when they're proposed, very few folks who aren't a lawyer would even understand all that legalese words and jargon. And so it's a very difficult process, I think sometimes purposefully made so, for the participation of all of the folks on the street to participate in an effective, knowledgeable way. And so then what happens?
Well, we're
marketed to, right?
What happens is the marketing takes place, and that's in the media, where you're in this case, the act we're talking about, it's sold to the public as, hey, they're going to reduce our premiums. And everyone says, that's a great idea. This sounds great. Let's go ahead and do it. And then, of course, when there's a bait and switch, you don't usually find out about the bait and switch until you're actually the one affected by it. So in our case, we see victims of an accident, and all of a sudden they find out what happened, and they're like, I can't believe this. And we're like, well, our legislature did it.
So let's talk about, and again, we're talking to folks to encourage you to participate in this process, to be up to speed with what's coming up. And honestly, there's got to be groups that we find out about, and we're going to push, that give you notice of what's coming up to help you protect your own interests and those of your loved ones. But in the context of this Omnibus Premium Reduction Act, they were proposing, 4 things, as I recall?
Yeah, four main things. And one of them, without getting the legalese, is something called the collateral source rule, which is if you buy insurance, you buy health insurance, and you get an accident, and you've been paying premiums for years and years and years for that coverage.
It's your insurance company.
I bought the insurance to protect myself. I get into an accident because someone else hits me. My health insurance pays my medical bills. The way it used to be is the person that caused the accident, that hit me, that hurt me, they don't get the benefit of the fact that I've been paying premiums for 10 years. I get the benefit of that because I was the one that's been paying the premiums for 10 years. They've flipped that on its head now, to where now the insurance company, the auto insurance company,
gets the benefit.
Yeah, instead of saying, we're going to pay $100 for that x-ray, well, Blue Cross Blue Shield only paid $40 for that x-ray. We know Mr. Fagan's been paying premiums for all those years. Thank you very much, Mr. Fagan. But we're only going to pay $40 for that x-ray. And if, for instance, in an x-ray situation like that, it's up to the judge now under the new law, can go up to 40% of that $40 to reimburse me for the premiums I've been paying.
Gives you $16 more.
$16 more to compensate me for all the health insurance premiums I've been paying.
I was talking to our health insurance guy last week. Premiums have doubled since for the last 10 years.
Yeah.
And we have less coverage, higher deductibles, and you're paying more in premiums. And now you don't necessarily get the benefit if you're the victim of a horrible accident for your responsible behavior in buying appropriate insurances, disability, health, or otherwise. The at-fault party's insurance company gets the benefit.
That's right. It's not even the at-fault party because it's the insurance company. And so when you look at the passion that we're having right now in this conversation,
it's just not fair. It's absurd.
And we anticipated this a year ago.
Yep.
And yet it came to pass. And that's what's so frustrating as we see it here today, because we know that it won't change in the future.
No,
because-
it's only going to get worse in all likelihood. Well, there's three other parts of this thing that we'll talk about on the next segment. This is Locke Meredith with Legal Lines. My partner, Sean Fagan, talking about some bad laws, folks. Be right back.
Hi, I'm Sean Fagan of Locke Meredith, Sean Fagan and Associates. Open the phone book or look online. There are plenty of lawyers to choose from. And if you ask any of them, they'll agree that the vast majority of claims settle without ever having gone to trial. And I'll tell you, any lawyer can settle a claim. It's not hard to settle a claim, but it takes hard work to get a client what he or she deserves. At Locke Meredith, Sean Fagan Associates, we have a proven record of working hard for our clients. Whether you hire us at all, give us a call.
Welcome back to Legal Lines. I'm Locke Meredith. I'm talking with my partner, Sean Fagan. We're talking about some bad law that was passed last year. Became effective January 1 of this year, folks, and it harms the victims of accidents and benefits who? The insurance companies. So we were talking about the collateral source rule and how that's been modified. So that bottom line is, insurers benefit from my decision to buy disability insurance, health insurance, or any other insurance, paying premiums for years to make sure that if I have the need of that insurance, I will have it available to me. And now it's been turned on its head, and it benefits the insurance company of some moron driving down the road, sipping on a beer or whatever, who crashes into the back of me and paralyzes me. And it reduces his exposure, which really means his insurance company's requirement to pay full compensation for my damages and expenses.
Yeah.
Completely unfair. And the whole auspices by which this purported legislation was supported was to reduce insurance premiums for everybody. Not only did that not happen, they've increased them. Let's talk about some other wonderful aspects of the, what's it called now?
Now it's called the Civil Justice Reform Act.
The Civil Justice Reform Act. Okay, let's talk about the jury threshold change.
Jury threshold change was in order to keep cases moving, as you can imagine, especially with COVID now, right? There's a tsunami of cases that have built up over the last 20 months because courts have not been open. And one of the ways that helps get those cases through in a faster and more efficient manner is to have judges try the case. In Louisiana, if a case was worth less than $50,000, it could be tried to a judge, to the bench.
$50,000 was the threshold. So explain that. When you say $50,000 was the threshold, that means or meant what?
That meant that if the damages were below $50,000, $49,999, and below, you could try it to the judge without having to go through the expense and time delays associated with picking a jury. That's a very involved process. Takes a lot of the court's resources to get ready for a jury trial, whereas with a bench trial...
And way more expensive.
Tremendously more expensive. You have live witnesses where you can do witnesses by deposition. A judge can read the depositions. You can't do that to a jury without putting them to sleep. So they changed that from $50,000 to where now the threshold is $10,000.
They proposed $5,000.
They proposed $5,000.
And somehow it was amenable to go to $10,000.
Yeah, when I'm going up to $10,000, so that means that any case.
So if I'm in a wreck and my damages are greater than $10,000, it's going to be a jury trial.
Yep, which means virtually every accident someone can be involved in, just to fix your car.
Well, think about this. The minimum insurance liability limit is $15,000.
Yes. Mm-hmm. Yep, in Louisiana.
They didn't even go to that ridiculously low level.
No, and so what happens is fix your car. If it's a $5,000 fix for your car, and you've been to the doctor's office or to the emergency room,
They eat up $5,000 in a nanosecond.
So every case essentially is now going to be a jury trial, which now you've got this tsunami of cases that have been built up over 20 months. And in the 20-month period, other cases have been coming to the courts that haven't been dealt with. So it grows and grows and grows, and now it's going to be jury trials.
So, Sean, explain to folks what you think was the motivation for this great decision to reduce the threshold from $50,000 to $10,000 on the insurance side.
Well, on the insurance company side, it's rather obvious because one, the expenses go up tremendously for the people who are trying these cases, or the victims of whatever accident occurred.
We're making it harder for the victims.
Yeah, the victim can't get in
who didn't do anything wrong.
The victim has to go in now and pay more money to have doctors come live. Even in a $20,000 case, now they're going to have doctors come in live and do all things.
The ability to get a timely court date to litigate it compared to a bench trial, it's not even close.
So stretched out. So for folks who have lost income, they can't wait that long, and so you wind up they wind up saying we need to settle for 50 cents on the dollar because we might be owed $1, but we'll take the 50 cents because we need to pay bills now.
They want to make it more difficult and harder to resolve the matter using the system that our forefathers gave us that has worked for hundreds of years. They want to eliminate that. The access of the man on the street, the woman on the street, their access to what has worked for hundreds of years. And now they've made it so difficult, and they did it on purpose, to force folks to accept less just so they can get on with their lives and pay their bills, hopefully.
Which brings us to the next thing that they were legislated for, and that was in Louisiana, and as well in a number of other states, which is now being attacked in every state that you're allowed to sue the insurance company along with the person who hurt you. You sue their insurance company. Well, now in Louisiana, you can still sue the insurance company, but the jury can't be told that there's insurance out there. And you go, well, why is that? And the reason why, the insurance company said, the reason why is because we're concerned that if they know an insurance company is out there, a jury might award more money than the case is actually worth because, it's an insurance company, and so why not, run up the damages? Now, the flip side of that is, and this is what's not really being said, is, well, what about the possibility that a jury, if they don't realize an insurance company is there, will lower the verdict for the victim, because they feel that the person who has to pay doesn't have the money to pay, or isn't.
They like both parties. They don't want to hurt the guy who's at fault for causing the collision.
It was an accident. It was an accident. They didn't mean to do it. And so, but that's why we buy insurance, is because, it doesn't mean we're a bad driver if we hit somebody while we're adjusting the radio. It means at that moment in time we weren't being attentive. But it doesn't make us an evil person.
And so again, in either of those scenarios, either the victim gets too much money or the victim doesn't get enough money that's even close to fair because the jury is more concerned about the defendant. Once again, the victim is the one who suffers. Another provision was, before we do that, let's explain to folks, Sean, why the jury trial threshold is such a big deal. Let's compare, right? And you started to, but the judge, if it's a bench trial, it's not going to take a week or 2 weeks to litigate the matter, because number one, he knows the law. Number two, if he can be updated on the law and the parties can argue their positions in memorandum that he orders or that they submit in pretrial briefs and such, cite the law, you can attach all the evidence that doesn't require live testimony to it, affidavit, anything that he accepts. And all you got to do is maybe have one or two witnesses, like the person who hit the victim and the victim who talks about all his problems or her problems. And it's over in hours, usually, instead of weeks.
Well, it streamlines the process if for no other reason than what you just said. At the beginning of a trial, a judge will spend an hour letting the jury know what's getting ready to happen and explaining what's coming and how evidence works.
And that's before voir dire and all of it.
That's before you even get into the opening statements. Then you put on all the evidence, some of which a judge, as you said, could get by deposition, but it's coming in there live. And at the end of the trial, there's usually another hour and a half where the judge is explaining what the law is and going through a verdict form. It's so much more efficient when the judge does it because he knows all that or she knows all that. And a trial that may take a week to try to a jury, a 5-day week, might be within a day and a half in front of a judge.
And we didn't even point out that we already have very limited few folks that are willing to participate voluntarily as a juror. They sure ain't doing it for the money because they get paid, what, $12 a day or something like that? And it's a huge burden on a person who's got to be there at 7 a.m. or whatever. So it's obviously this is a problem that's going to need to be addressed. All right, we're going to continue this on the next segment. This is Locke Meredith, my partner, Sean Fagan. We'll be right back. Bad laws, folks.
Hi, I'm Mitchell Meredith. At Locke Meredith, Sean Fagan and Associates, we know each case and client are unique, and that no two cases are the same. But one thing remains constant, and that is our passion to help our clients. After an accident, we know your life has changed, which is why we passionately fight to make you and your family whole. Remember, whether you hire us at all, give us a call at 272-5555. We're here to serve you.
I'm lawyer Locke Meredith. Among the most important factors to consider when you're hiring an injury attorney is trust. You trust your attorney will put your interest first, treat you with respect, fairness, and honesty. You trust them to be there for you when you need them. At Locke Meredith, Sean Fagan and Associates, thousands of clients have trusted us to represent them, and for good reasons. Please visit us at LockeMeredith.com to learn more, and whether you hire us at all, give us a call at 272-5555. You have nothing to lose.
Welcome back to Legal Lines. I'm Locke Meredith. We're talking about some bad laws, folks. I'm talking with my partner, Sean Fagan. Let's dive back in, Sean. We're talking about some bad laws. Let's talk about the last part of it. We talked about collateral source, how that screwed the victims, benefited the insurers. We talked about the jury threshold, same scenario. Let's talk about the prescription issue.
Okay. The only thing that could offset slightly some of the stuff they had in that bill was to expand the amount of time that a plaintiff could use to resolve the claim with an insurance company. Because in Louisiana, it's a 1 year, what we call a prescriptive period. That's the time within which you have to file a lawsuit.
1 year from the date of the accident where you get hurt, you better file a lawsuit or that claim is gone.
That's right. And Louisiana is one of the few states that has 1 year. Some states have 5, 6 years. Louisiana is extremely short. So a plaintiff has to work, any accident victim has to move very quickly.
And somebody who's horribly seriously injured, they're not even be through treatment within a year.
That's right. And so what the original bill, the Premium Reduction Act, when it was billed as that, was going to extend that out to 2 years to keep people from having to incur the cost of filing a lawsuit.
And have more time to get fully treated and to resolve it amicably in terms that both parties thought were fair.
That's right. And so now,
but guess what,
since it's a year, and now that they've added on all the lower threshold for a jury trial, they've done all these different things, the costs are going to ramp up very quickly for a victim. And so now, as they see the costs going up much more quickly, it puts them at a disadvantage because they're going, wow, I need to stop the bleeding. I need to resolve this case. Again, it benefits the insurance company, not the person who's hurt. And that's the thing. We've talked about this, and again, I said it earlier that we know there's so much passion about this is because we're watching this across society right now.
That's right.
It's, people.
We see the results of this bad law. And so the bottom line is, in this case, no premiums reduced. The insurance company got everything they wanted. And how? Because they're required to pay to the victim less money, and the victim has less time to file the suit, and the victim benefits not one iota because they are forced, because of their own necessitous circumstances, to resolve it because they can't wait any longer because it's so time consuming to litigate it. It's not fair. That's the bottom line. And this isn't the first time this has happened. Let's talk about medical malpractice.
Yeah, medical malpractice was 1976.
Explain to folks the whole kind of big picture there.
Well, the idea, this was again from, pushed by the insurance companies that were providing professional insurance to the physicians for malpractice. And what happened in 1976? They said, well, look, there's so many physicians being sued in the state of Louisiana, they're just going to leave the state. We want to have a single doctor here. Insurance premiums are going to go up too much, and so if they can't get insurance, they're all going to leave. And this was being pushed in every state around the union. I don't know where the doctors would have moved to, because every state was getting the same type of pitch being given to the legislature. Well, Louisiana passed the Medical Malpractice Act in 1976. It set a maximum recovery for injuries at $500,000 for general damages. You get a leg, if you're 12 years old and your leg is amputated, you would get the same amount maximum as a 76-year-old who got the leg amputated, even though you've never worked a day in your life and it may keep you from earning a living.
So your loved one died.
Yes.
That's it, baby.
It's a maximum amount. So what happened over the last 45 years?
Now, they do get future medical expenses.
They can get future medical expenses, but in terms of economic expenses, lost wages, that stuff, it's all within that $500,000 cap.
And it was supposed to do what? Reduce the premiums for doctors.
That's right. And of course, it didn't.
Yeah, ask any doctor folk have their premiums stayed the same that they were paying in 1976? The answer is no.
No, it's gone up, and it's gone up year after year. And so now you've got this situation where the doctors didn't get the benefit of it, even though they were told they would get the benefit of this. They're still paying out left and right side of their pockets.
So once again, the only party who benefits is the insurance company.
That was it. That was it. They have, in 45 years, despite the fact that what you could buy in 1976 for $10 is not what you could buy now for $10, they've never raised it above $500,000. In 45 years, no adjustments for inflation, because every time it comes up, the lobbyists push against raising it.
Bottom line is $1 back in 1976 might have bought you, I don't know, a popsicle, and now you might get who knows, a grain of sand?
It might buy
Your dollar doesn't buy what it used to. Listen, so failed there, just like it failed last year to do what it proclaimed that it was going to do. What about no pay, no play?
Something you and I think is a good idea overall. The whole idea of no pay, no play is that if I don't buy liability insurance, that means if I hit you and caused you injuries and I had no insurance, you might get nothing. Unless you had uninsured motorist coverage,
which I paid for,
which you pay for, you would get nothing. So the governor said, that's just not quite fair, because what if you hit me? Well, if you hit me and you've got insurance, I can get money from you. But again, if I hit you, you couldn't get money from me. So they said, that's just not fair. So we're going to give a credit to the person that hurt me in the amount of $15,000, because that's the kind of insurance that I should have had if I hurt them.
That was the minimum limit required.
The minimum limit in Louisiana. So $15,000, I get a credit for it. So in that case, the insurance company gets 100% of the benefit of that law. In which they get all the $15,000, credit for that. What the irony is, the victim under this new law that now says you can't have a collateral source. You've bought all this health insurance. Now the victim doesn't get the benefit of what they paid for with the premiums. It benefits the insurance company.
Again.
Yes, because instead of paying $100, which is what the bill was for if you didn't have insurance, now and your health insurance paid $40 of that bill to pay it off. Now the auto insurance company only pays $40.
So Sean, the bottom line is these are examples over the last 45 years where legislation was passed that was alleged to help the general public by reducing insurance premiums or a profession like a doctor that you got to have here. And in fact, it didn't. And that screams to us, not only for us, but for everybody. We must become engaged in politics right now. Mm-hmm. Money controls everything. You can see it at the federal level, you can see it at the state level, you can see it at the local level. But we still have the power as the public. We still are a democracy, democracy. And we have a voice, and you must exercise it, folks. You have anything else to add?
Participate. That's the thing.
Get educated and participate, folks. Been Locke Meredith Legal Lines. My guest, my partner, Sean Fagan. Thank you for being with us.